We have some breaking news. A 24-page motion has now been filed in Trump's IRS lawsuit in the Southern District of Florida. Now, you may be thinking, but Katie, I thought that case was over. And technically, you would be correct. I have the order closing the case that was signed by Judge Kathleen Williams on May 18th, 2026. However, remember that this order closing the case was only entered by Judge Williams after Trump, his two unsuccessful sons, and the Trump Organization LLC filed a notice of voluntary dismissal with prejudice. But we all know that Judge Williams, from the very start of this case, suspected collusion between Trump, the IRS, and the Department of the Treasury. In other words, Trump was controlling both sides of the lawsuit, and that is why Judge Williams, as we have covered extensively here on Katie Fang News, ordered all parties on opposite sides of the case, as we call it, plaintiff versus defendant. Judge Williams ordered them not only to file legal memoranda supporting their claim that there was a real controversy between the parties, but also to appear in court and present oral arguments. In other words, under oath, they had to make representations to the court about the existence of this controversy. She also, because she believed collusion was taking place, Snorts, ordered the appointment of 3 amici, friends of the court, who filed detailed legal memoranda of their own, essentially telling the court, your concerns are well-founded. You should conduct further inquiry into what the hell is happening here, because we also suspect that Donald Trump is controlling the lawyers representing the Department of Treasury and the IRS. And lo and behold, suddenly, this so-called settlement agreement was entered that was never shown to the court, never reviewed or approved by the court. And that so-called settlement agreement, which we all know resulted in the $1.776 billion so-called anti-weaponization fund, is really just a slush fund built from money taken from American taxpayers. Now, where do things stand today? Well, Acting Attorney General Todd Blanche, who also serves as Donald Trump's personal attorney, has been making the rounds, not only in the media, but also trying to ease concerns in Congress about the existence of this slush fund. And even though he has been dancing around the issue, we all know that insurrectionists, yes, people who attacked law enforcement and damaged and defaced the United States Capitol on January 6, 2021, are eligible to apply for reparations paid by us as American taxpayers. Many of us, myself included, have been losing our minds over this because it is theft of American taxpayer money. But I am here to share some good news. This motion has been filed. This is breaking news. 35 former federal judges in a bipartisan action, meaning they were appointed not only by Democratic presidents, but also Republican presidents, have now filed this motion for relief from judgment under Rule 60 of the Federal Rules of Civil Procedure, or alternatively, a motion seeking permission to appear as amici, friends of the court. I want to emphasize that 35 former federal judges have now gone to Judge Williams to say, you know that order you issued? You can actually vacate it because there is a rule of civil procedure that allows further inquiry into what the actual hell is going on with this so-called settlement agreement. So let's go through the details because they are important. Let's start with the actual rule of civil procedure. All right. Rule 60. Relief from a judgment or order. Now, on motion and just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for these reasons. And it lists them all, right? Those are grounds for relief from a final judgment. Now, it sounds like, gosh, a party involved in litigation has to be the one or ones that move. But no, this motion says otherwise. In fact, we can come to you. We're non-parties, but we can come to you under Rule 60 and ask you to set aside this order closing the case and allow the court, Judge Williams, to make further inquiry into what happened here. Let's start with the first page of the motion. Movants are 35 former federal judges. Movants are filing this motion because they have dedicated their professional lives to the administration of justice. The reported, quote, settlement the parties never placed before this court raises profound questions about the parties' candor to the court and manipulation of the judicial system, which threatens to undermine confidence in the administration of justice. As former judges, the movements have an interest in bringing these concerns to the court's attention and in pointing to the availability of relief under Rule 60 of the Federal Rules of Civil Procedure, which allows a court to set aside a judgment and reopen a case. The 11th Circuit, which is the appellate court above Judge Williams, has held that in extraordinary circumstances, and that is in quotes, a non-party, meaning these judges, may bring a claim of fraud on the court under Rule 60, even when the non-party's interests are not directly impacted by the judgment. Alternatively, the movements seek permission to file as amici, meaning friends of the court. The court clearly has the authority under Rule 60 to reopen a case on its own, meaning on its own initiative. So this is a very important point I want to pause on. These 35 former bipartisan federal judges are telling a fellow judge on the bench, Judge Kathleen Williams in the Southern District of Florida, that she can act on her own without any motion before her, and she has the power to reopen this case. If the court chooses that path, the movements seek permission to file this brief as amici in the reopened case. In either case, the movements ask this court to use its authority under Rule 60 to set aside the judgment in this case, allowing the court to continue its review of whether there is a real underlying case or controversy, or whether, on the other hand, this case that the parties claim was settled is itself a fraud on the court. Moving on to the next page, the court was misled. Even though the plaintiffs did not mention any settlement in their notice, meaning their notice of voluntary dismissal with prejudice, the Department of Justice publicly announced a so-called settlement of this case shortly after the plaintiffs filed their dismissal. That so-called settlement takes the fabricated sum of $1.776 billion from the United States Treasury and distributes it to recipients selected by a commission effectively controlled by the president. The DOJ is calling this the Anti-Weaponization Fund. The parties in this case are using this lawsuit as the legal basis for these actions. This is not guesswork. The parties themselves have said it many times, and the motion goes on to list all the times it has been called a so-called settlement or settlement agreement. Yet none of the parties filed any of these documents with the court. These 35 former federal judges say, "We submit that this so-called settlement is the result of collusion and is itself a fraud on the court." But the court does not need to decide that final issue now. At this stage, the movements only ask the court to use its power under Rule 60 to set aside its order, closing the case based on the plaintiff's voluntary dismissal. That would then allow the court to begin an inquiry into whether the court was misled, including on whether there was ever a real underlying case or controversy, and any claimed arm's-length negotiations used to resolve it. This court has the power under Rule 60 to determine whether there has been a corruption of the judicial process itself, and may set aside a judgment and reopen a case under Rule 60, subsection D(3), as well as other parts of Rule 60, whether through this motion or on its own, meaning the court itself has the authority to set aside the judgment and reopen the case. Now here's the point. It goes on to make the legal arguments for why Rule 60 allows Judge Williams to do this. And it repeatedly states that these are extraordinary facts and circumstances. And I would tend to agree. Would you not? I mean, since when in the history of our country has a president sued his own IRS and the Department of the Treasury, and then entered into a fake settlement that amounts to theft of American taxpayer money? And then, have you forgotten? There was that addendum to the settlement agreement that basically waives the United States government's ability to audit the president, his family, and his business entities to possibly look into and determine whether any fraud, evasion, or crimes were committed by them. It is truly unprecedented, and that is why it truly reaches the level of so-called extraordinary circumstances. And that is a phrase that is repeated throughout this motion because it does allow the court to make further inquiry, because under these extraordinary circumstances, I think the court should determine whether collusion is afoot, as Judge Williams has suspected from the very beginning. These judges are not holding back here. They say the parties have committed a fraud upon the court. These judges are telling their colleague, Judge Williams, that she has been the victim of a fraud that has been carried out on her court, and that she has the inherent authority as a judge to uncover this fraud, investigate it, and also take action on it. I mean, there is a big difference between a group of federal prosecutors, former federal prosecutors, maybe even lawyers, right, coming forward to the court and saying, hey, as amici, as friends of the court, we want to let you know that you can take certain actions. And let me footnote this, because this is important. But we do know Judge Williams has actually followed the advice of lawyers. We saw this remarkable filing, an amicus brief, that came in essentially to tell the judge that she could appoint lawyers to file their own independent memorandum on whether this was a collusive lawsuit, and she did that. She appointed 3 strong lawyers who prepared their own legal memoranda ahead of the deadline to inform the court that whatever was going to come from the parties in this case, they wanted to explain what was really happening. So Judge Williams has the humility, which is remarkable for a federal judge, to say, I'm going to listen not only to lawyers, but also to other judges, and that is what is going to happen here. I would bet bottom dollar that Judge Williams in this case says, you know what? I am going to set aside the judgment, and I am going to reopen this, because her order closing the case made sure she noted on the second page, because the notice does not reference any settlement or include a stipulation of settlement, there is no settlement on record. Additionally, the defendants, federal agencies represented by the Department of Justice, which has an independent duty to protect the public's strong interest in knowing about the conduct of its government and the use of its resources and the fair administration of justice, did not submit any settlement documents or file any papers confirming that a settlement was proper, where there was still an open question about whether a real case or controversy existed. That was not an accident that Judge Williams included that in her order. I am telling you, Judge Williams, from the very first moment this case was before her, has sniffed out and exposed the collusion here. And she has set them up, meaning Blanche and Trump and all these people, she has set them up to fail. And now with this motion, Judge Williams has all these former federal judges saying, yeah, we know what you want to do, and you can do what you want to do. The sequence of events that led to the plaintiff's voluntary dismissal with prejudice makes the collusion strategy clear. We have talked about this here a lot, right? I am actually very proud. I want to pat myself on the shoulder for a moment here. I said from the very beginning, when the settlement agreement issue came out, you may recall I said, but where is the consideration? Remember, we talked about settlement agreements and how they are contracts, right? They are binding contracts. One side of the settlement agreement has to do X, Y, and Z. The other side of the settlement agreement has to do A, B, and C, and those are the terms. And if you do not meet those terms, you are in breach. So it is a contract. It is a settlement, right? It is an agreement. And I said, but what is the consideration? In order to enter into an agreement, in order to enter into a contract, you must have consideration. You must give up something to receive something. In this case, what is it? And this motion clearly notes that there is an absence of consideration. The plain language of this extremely broad provision, the one that deals with the IRS being unable to conduct audits, etc. The plain language of this extremely broad provision also covers Internal Revenue Service audits of the plaintiff's tax returns and all other claims the United States may have against the plaintiffs. Extraordinary benefits for which no consideration was given to the government. I mean, I have been doing this for almost 3 decades, but my point is this. It is, on its face, completely wrong, the so-called settlement agreement. It is, on its face, just outright theft And that is why many of us are so upset about it. At least those of us who believe in the rule of law and recognize when theft is taking place. Accordingly, because the parties' collusive conduct committed a fraud on the court system itself by creating the appearance of opposing parties when in fact there were none, the court should void its prior dismissal and reopen the case to determine in due course whether a fraud occurred. And then it goes on to explain how the court has the authority under this rule of civil procedure to do exactly that. And again, that the court can act on its own, even if this motion by the former federal judges is not granted. It also, this motion, argues that the settlement is not even eligible to draw funds from that judgment fund to create that so-called anti-weaponization fund itself, because you actually need active or imminent litigation for the DOJ to be allowed to access the judgment fund. And if you have a fake or collusive lawsuit, then that is not truly active or imminent litigation. So taking that money out of the judgment fund to place it into the accounts of this so-called anti-weaponization fund also does not work. So these judges understand that as well. They know what is going on here. For these reasons, the court should set aside the notice and order of dismissal and reopen the case for further proceedings. I am very proud to say that Democracy Defenders, where I serve as a senior advisor, my dear friend, former Ambassador Norm Eisen, filed this motion. Snorts. And former Attorney General of New Jersey, Matt Platkin, a strong and skilled defender of the rule of law and democracy, he filed it, and my other good friend, Justin Nelson at Sussman Godfrey. If that name sounds familiar, they are the lawyers who represented Dominion Voting in that major, historic settlement with Fox News. Sussman Godfrey is also being targeted by the Trump administration. They are one of 4 law firms that did not give in or submit and did not pay money or do other things like some of the larger law firms did under the administration. So, a round of applause for these strong lawyers, and an even louder round of applause for these 35 former federal judges who have filed this bipartisan motion before Judge Williams in the Southern District of Florida in Trump's IRS case. We will be watching this closely. I expect we will get a ruling from Judge Williams very soon. Watch this space. We will cover it here. In the meantime, stay maybe outraged and demand accountability. I'm off to shake things up again. If you have not subscribed, please like and subscribe. Share this episode widely. Let people know the truth about what is happening. I will see you on the other side. Katie Fang here. We launched the Katie Fang News Channel in partnership with the Midas Touch Network, so we could bring you the latest legal and political news straight, no filter. So if you are a fellow truth teller, hit that subscribe button and spread the word about this channel so we can build a high information America together.